Article 14, Liberty and Security of Person. This article begins with two comments highlighted in panels. Young people who have an invisible disability such as fetal alcohol spectrum disorder, FASD, and autism often end up in prison because they did not get the support they need. Survey respondent. Seclusion continues to be used inappropriately, especially with people experiencing dementia. Survey respondent. Introduction. Article 14 recognizes that disabled people should have their freedoms protected by law on an equal basis with others. Any deprivation of liberty must be in conformity with the law, and the existence of disability shall not justify a denial of human rights. General comment. This article is of pivotal importance as it deals with disabled people who are in prison, secure health or disability services, or other places of detention. Disabled people in these environments can be particularly vulnerable to exploitation or abuse. Reasonable accommodation should be provided to ensure a person's disability does not lead to unintended and further deprivations of liberty. Importance of Article 14 to disabled people in New Zealand. Realisation of the rights in this article requires changes to New Zealand's current legislative environment, where a number of acts have been criticised for their lack of human rights principles or the absence of free and informed consent. Protecting the liberty and security of disabled people who are in restrictive environments is paramount and must continue to be monitored. Current place of Article 14 in law and practice. Current law and practice in New Zealand does not adequately reflect Article 14 of the Disability Convention. New Zealand's current legal framework, particularly legislation pertaining to health and disability, is based on a process of substituted decision-making rather than supported decision-making. As outlined in Article 12, a number of acts should be reviewed. End note 126, with a focus on replacing the medical model with contemporary disability thinking, such as the recovery model. The IMM acknowledges the government is currently reviewing the Mental Health Compulsory Assessment and Treatment Act 1992. However, overall progress is too slow in this area, and some legislation adopted by the government after ratifying the Disability Convention violates the rights of disabled people to liberty and security. There is no systematic program of legislative review and reform in place to ensure that non-compliant legislation is identified and progressively brought into alignment with the Disability Convention. Committee's previous dialogue with the State on Article 14. In its 2014 concluding observations, the Disability Committee recommended that New Zealand, end note 127, take all the immediate necessary legislative, administrative and judicial measures to ensure that no one is detained against their will in any medical facility on the basis of actual or perceived disability. The Disability Committee was concerned that the Mental Health Act has been criticised for its lack of human rights in principles and recommended that, end note 128, all mental health services are provided with free and informed consent of the person concerned in accordance with the Convention. It further recommended that the Mental Health Act be revised so that it complies with the Disability Convention. The Disability Committee was also concerned that the criminal justice system in New Zealand includes conditions in which disabled people are declared unfit to stand trial, and on this basis can be deprived of their liberty. It is stated that the system does not recognise that a disabled person should only be deprived of their liberty when found guilty of a crime after a criminal procedure has been followed with all the safeguards and guarantees applicable to everyone. Based on this, the Disability Committee recommended a review of safeguards and guarantees for disabled people in New Zealand's criminal justice system. It further recommended that New Zealand ensure that disabled people in prison were afforded reasonable accommodation. Comment on the realisation of Article 14 in New Zealand. There is much work to be done. Since New Zealand last reported to the Disability Committee, the Substance Addiction, Compulsory Assessment and Treatment Act 2017 has been enacted. The Act allows for compulsory assessment and treatment of people that is counterintuitive to contemporary mental health philosophy. The IMM made written submissions against the Act, noting issues with respect to Article 14 of the Disability Convention. Our submission emphasised the Disability Committee's previous comments on the Mental Health Act, and our belief that the Disability Committee will make similar criticisms of the coercive aspects of the Act, along with the fact that New Zealand now has additional legislation that allows compulsory assessment and treatment. Section 120 of the Act requires the Ministry of Health to conduct a review of the operation and effectiveness of the Act and report to the Minister of Health after the legislation has been in effect for 3 years. New Zealand, like most countries, has significant work to do in order to comply with Article 14. United Nations Special Rapporteur on the Rights of Persons with Disabilities, Catalina Devandas Aguilar, made the following statement in her report to the Human Rights Council in 2019 about the global situation. End note 129. The deprivation of liberty on the basis of impairment is a human rights violation on a massive scale. Persons with disabilities are systematically placed into institutions and psychiatric facilities or detained at home and other community settings based on the existence or presumption of having an impairment. They are also overrepresented in traditional places of deprivation of liberty, such as prisons, immigration detention centres, juvenile detention facilities, and children's residential institutions. In all these settings, they are exposed to additional human rights violations, such as forced treatment, seclusion, and restraints. Ms. Devandas Aguilar's concerns are echoed by members of the deaf community in New Zealand, who feel there is a lack of reasonable accommodation in the provision of culturally and linguistically accessible mental health services and support services for deaf people. Recommendations. The IMM recommends that the government 39. Implement the formal recommendation made in the Inquiry into Mental Health and Addiction to repeal and replace the Mental Health, Compulsory Assessment and Treatment Act 1992 in partnership with people with experience of mental distress, including wide consultation with tangata whaikaha without delay. 40. Action paragraphs 33 and 34 of the Disability Committee's concluding observations to eliminate detention in medical facilities on the basis of actual or perceived disability, provide treatment only on the basis of free and informed consent, and eliminate the use of seclusion and restraint in medical facilities. 41. Ensure that the review required by Section 120 of the Substance Addiction, Compulsory Assessment and Treatment Act 2017 is implemented comprehensively.